If a court decision were a ship, and the decision were to lose all continuing significance, it would be described as a derelict on the waters of the law. But if the 1983 decision of the Delaware Supreme Court in Weinberger versus UOP were a ship, it would still be going full steam ahead, now nearly 40 years later. In the annals of Delaware case law, Weinberger remains one of the most frequently cited cases. Still, known for clarifying corporate law's entire fairness standard for judging transactions affected by conflicts of interest. Endorsing the use of special committees of boards of directors to review and approve such transactions. Opening up judicial valuation proceedings to techniques used in modern corporate finance. And foreshadowing cases that have effectively compelled boards of directors and their financial advisors to engage in serious deliberation when it comes to considering mergers and acquisitions. And yet, Weinberger was a case that escaped multiple brushes with extinction, and the opinion we still study almost never happened. To tell the story of this enormously important case, this video includes interviews with 3 people who played a role in the litigation. Michael Hanrahan, a partner in Prickett, Jones, and Elliott, who helped represent the stockholder plaintiffs. A. Gilchrist Sparks III, who represented defendant Signal, UOP's majority stockholder. And Grover C. Brown, the former chancellor who produced the many decisions in the Court of Chancery. To set the stage, some brief background. Signal, UOP's majority stockholder, was no stranger to the Delaware courts. In fact, its appearance there in 1973 in the case of Gimbel versus the Signal Companies was a direct precursor of the merger attacked in Weinberger. On Christmas Eve 1973, in the midst of a worldwide energy crisis, a stockholder of Signal filed suit in the Court of Chancery to enjoin the sale of Signal's oil and gas subsidiary to Burma Oil for $420 million. The court approved a preliminary injunction, but bearing in mind the risk of losing the best offer that Signal has had, required the plaintiff to post a bond in the amount of $25 million, which the plaintiff was unable to do, and the sale went forward in early 1974. Flush with cash, Signal went hunting for a way to invest it, and just the following year, in 1975, bought a majority of UOP's stock at $21 per share. But other efforts to invest its cash didn't pan out. So in 1978, Signal decided to buy the UOP stock that it didn't already own by means of a cash-out merger. And that's what led to the case of Weinberger versus UOP. And we can now introduce the participants in that litigation who share their recollections about it.
So let's start with the plaintiff himself, William Weinberger. William Weinberger had been the plaintiff. I know this because I Googled it up. I knew he'd been in a lot of cases, but I Googled it the other day to see if when it was he passed away, which by now he clearly has, since he was in at least his mid-80s when this suit began in 1978. And he by that time had already been involved in at least 90 federal securities law cases as a plaintiff. He was in a number of Delaware cases, including at least 1 or 2 that I know Vice Chancellor Brown commented that he had decided. In fact, I think at one point the Vice Chancellor was remarked that it didn't appear that Weinberger remembered the case that Vice Chancellor Brown had decided that he had been the plaintiff in.
Representing Mr. Weinberger along with Mike Hanrahan was one of the more colorful characters in the Delaware bar, the late William Prickett.
The lead lawyer in Delaware was Bill Prickett.
Yes.
What were your impressions of Bill?
I don't know if I should say all that on camera or not, but now Bill was a very good trial lawyer. I got my experience with Bill in his office when I first started practicing law down in Dover, because back in those days, his firm did defense work for insurance companies in personal injury cases. When it came to Chancery, then by that time he got into some of these things, and I was familiar with Bill, and he was a good litigator. He was a good litigator because he spent a lot of time in court, cross-examining witnesses, and he knew how to handle himself. And he was ornery. He liked to have a sense of humor, and he liked to get at things. And I was just familiar with Bill. He was a good attorney. Knew what sometimes he would have rather preposterous approaches to things, but if you called him on it, he'd back off and come another direction. But no, he was good, and he was colorful. You kind of always enjoyed Bill coming into court because you knew it wasn't going to be another dreary argument. It was going to be. Bill had I observed, he had a knack for always in court wanting to poke some kind of a jibe at the opposing attorney along the way by, little things like if my worthy opponent on the other table had read the cases that he cited in his brief, he would know that his case is absolutely unsupportable or something like that, which would cause the other attorney to get up and say, Your Honor, I've read all those cases. And, well, I observed, my observation over the years was Bill did that just as a tactic. He wasn't mean about it or anything. He just poked the jibe to get the guy off his train of thought, his opponent. His opponent was there to make an argument, probably things racing through his head that he was going to say to the court. And Bill would say something to cause him to forget all that and have to defend his honor or something. He was colorful like that.
Describing one of Mr. Prickett's courtroom encounters, his partner Mike Hanrahan recalls this colorful quality fondly.
I remember that the first thing the chancellor said was, "Gentlemen, why are we here?" And Bill Prickett's response was, "Money, Your Honor." Bill had a way of getting to the point.
The defense side, including UOP's CEO James Crawford, probably wouldn't object to being described as much less colorful.
So basically, in our shop, it was me representing UOP, and I looked through the papers. I don't ever see that I even had an associate working for me. In fact, when the case started, I was an associate. I became a partner in 1979. So when this case began, I was a sixth year associate. I really didn't have anybody to report to. There was no general counsel of UOP. So I was, nominally, I guess I would take my direction from Mr. Crawford. But after the merger had occurred, UOP was wholly owned by Signal. And the lawyers at Signal, their general counsel was a guy named Brewster Arms. And then they had a senior guy from Latham and Watkins, Alan Halkett, who was really the lead counsel in the case. Now, whenever there had to be a UOP witness, like Crawford or a financial person from UOP, I took those witnesses. Halkett took all the rest of the witnesses.
Whatever color defense counsel lacked, the trial judge in the UOP case more than made up for it, as his extensive description of his path to the Court of Chancery demonstrates.
Could you describe your practice until you joined the court?
I'm a native of Harrington, Delaware, if I should bring that in. But so I was born in Delaware, and when I got admitted to the bar in Dover, I think I was the 15th lawyer in town back then. And of the 15, 5 or 6 of them were old guys that had been around that were just sitting, counting their money and that sort of thing. And so I was fortunate that it was a good opportunity, because when there weren't many lawyers in town, particularly who went to court, you got a lot of chance to go to court, because in those days there was no public defender. And anytime a person was brought in and charged with a felony and was asked by the judge, do you want counsel because they have no money? And they said yes. I got a lot of those appointments. And that always happened in first and third Fridays of every month in those days, in the Superior Court was criminal arraignments and divorces and that sort of thing. And so you had to go over for the criminal arraignments because you generally had somebody. But in the old courthouse down in Kent County, there's big pillars, two big pillars that are around council table. And I used to try and hide behind the pillar. You know, I'd sit so I'd have the pillar between me and the judge. But it didn't work because the judge knew I was there, and every now and then somebody would say they needed a lawyer, and Judge Story or somebody would look around and say, "Mr. Brown, is that you behind the post?" And, "Yes, Your Honor, I'm appointing you to represent this man." And so, yeah, no, it was good. In hindsight, it was a very good experience because you got to go into court, you dealt with the judges, you had to know what you were doing.
How did you end up joining the bench?
Well, as I told you previously, basically by default, I was practicing by myself in my little office next to the theater there at Dover, and I was initially asked at some point to become a judge on the family court. I thought, well, I don't know that I want to do this because I'd spent a lot of time in the family court defending all sorts of things, and it wasn't what I particularly wanted to do, but I thought, you know, I'm here by myself. I don't make a lot of money. I enjoy it. I was married. I had a little girl. And I thought, this doesn't make much sense. I think, you know, back in those days it paid $27,000 a year, which wasn't bad back then. And I thought I'd better take this because if something happens to me and I die, at least, you know, there's a pension, take care of my wife and daughter and that sort of thing. And I thought if I don't like it, I can always quit. So I became a family court judge.
How did you end up on Chancery?
Well, I was on the family court for, what, I guess 3 years, 2 years, something like that. In any event, it wasn't what I really wanted to do because, as I said, I was a third judge, a swing judge downstate. And there was a chief judge in Kent County and a chief judge in Sussex County, and I was the guy in between, so I had to run back and forth between the counties. And, you know, got most of the crappy jobs because, you know, rank has its privileges. And I'd done this for a while, and then I got to thinking, you know, I don't think this is what I went to law school for because I never wanted to do it in the first place. And but I didn't know how to get out of it because I didn't have a practice I could go back to. But in any event, there became a vacancy because the downstate vice chancellor, Isaac Short, his term was up. And Ike, as everybody called him, not to his face, of course, but he didn't want to be reappointed. He'd had enough. And so you needed a downstate vice chancellor who, in the constitutional scheme of politics, had, again, to be a Republican. Ike was a Republican, so you had to replace him with a Republican. In those days, people were coming over from Washington and Baltimore to the beaches and that sort of thing, and all the attorneys in Georgetown, there weren't that many, probably only 20-some, they were all making good money on real estate settlements and that. And nobody wanted to give up what they were doing, become a vice chancellor for $27,000, $28,000 a year, whatever it paid. And so, but it was their position. They had dibs on it because they had the office, they had the facility, and they had the retiree. But they couldn't find a candidate. Nobody was interested. So the Sussex County Bar Association met and ended up drafting one of their members who was not there at the meeting to defend himself, but they drafted him as their candidate, and his name was Jackson Dunlap, J. Dunlap. Nice guy, kind of practiced by himself. And I knew Jay because his wife was a cousin of mine. I gave her away at the wedding because her father was dead. But they drafted Jay. And I simply told the fellows in Kent County, I said, you know, there's 2 or 3 lawyers in town that if they're interested in this position, they should have it. But if you can't find a candidate, you're desperate for somebody, throw my name in. And so that's how it turned out. Nobody in Kent County wanted to bother with it either. And so that caused a big problem because the corporate bar up in Wilmington, which I knew nothing about at the time, I guess was horrified at the prospect that the third member of the Court of Chancery is going to be one of these two yokels from downstate. One's a family court judge, and the other's a some small-time practitioner, never been in Court of Chancery in his life. And so they imposed upon the governor to they had a committee of I would say corporate lawyers. I assume they were all corporate, 8 or 10 of them, but they wanted to interview us, see who they could stomach, I guess, of the two, because that's all they had. And so that was set up for interviews in Dover. Jay's was supposed to be at 10 o'clock and mine was at 11. When I originally heard that, I told my brother, I said, those silk stocking bastards up in Wilmington, tell them go to hell. None of them ever set foot in the family court. I got to go sit down and be interviewed by this gang. I'm not of their number. And he said, now, don't be hasty. And so I agreed to be interviewed. So the day the interview came, and I was sitting in my office in the family court in Dover waiting for my 11 o'clock appointment when Wesley Atkins, who was the bailiff for the Supreme Court for many years, quite a fellow, he came knocking at the door and said, Mr. Brown, they're waiting for you. And I said, well, my appointment's not until 11. Mr. Dunlap's at 10. He said, Mr. Dunlap withdrew. And I was all they had left. So I went over and got interviewed and was asked questions and that sort of thing. And as a result, the downstate bar had no other choice, I guess, and thereby did I become a member of the Court of Chancery.
And the UOP case was one of the most famous cases Chancellor Brown would preside over. It was commenced in July of 1978, a couple months after the merger, and some 4 months after the deal was announced. A fact that in later times might have killed off the case at the outset.
Was there any pre-closing litigation?
Not that I recall. And that's interesting because the agreement with respect to the merger agreement preceded by about 2.5 months the vote on the merger agreement. So there clearly could have been pre-closing litigation, but there wasn't. And I think that may have also colored people's thinking about the case as it began and as time went on.
After the litigation began, did anyone make an argument that the plaintiff should be kicked out of court because he waited too long to bring suit?
Not in the way that you would make that argument today. The law just hadn't developed far enough to in effect penalize you for not suing before the deal. I don't recall anyone making that argument. I do believe that on at least one occasion, maybe two, Vice Chancellor, later Chancellor Brown, made some mention of the fact that, by the way, nobody challenged this beforehand, and it may well be that it colored his thinking about the suit in sort of a global way.
What also colored Chancellor Brown's thinking was a controversial opinion issued by the Delaware Supreme Court a year earlier in a case called Singer versus Magnavox. Chancellor Brown was acutely aware of Singer. He was a trial judge who got reversed in that case, and that seemed to make him cautious about dismissing the Weinberger complaint too quickly.
In a later opinion, you wrote about it. To view this as pleading conclusions is to recognize the obvious. Under the decision of Singer versus Magnavox Co., however, this appears to be sufficient to state a cause of action and to require the court to hold a fairness hearing. Could you tell us a little bit about Singer and what you were referring to there?
Well, Singer was one of those earlier corporate cases that you were talking about. Did I have any of them? And that had come in. That was my case. And that was where, I guess it was North American Phillips, big company, had decided to acquire Magnavox and had enough shares, accumulated enough shares, I forget how, but had more than 50%. So, and they decided to simply cash out the minority shareholder through a merger. And they had a subsidiary and merged Magnavox into the subsidiary, with Magnavox being the surviving corporation, and put it out to the voters, which was approved. There was no problem, but it went up on appeal. Well, in front of me, the argument was, various arguments were made. I can't remember what, but I issued a decision and say, well, that's what the statute says. It says, the corporate law says if you have, majority voting control, you can use it. And I couldn't find anything really terribly wrong on the facts of the case with what Magnavox had done, but it was appealed, and the Supreme Court reversed, and I think fair to say established some new law, and came forth with, and maybe it was deserved, quite frankly, but they came down with a decision that said it's a violation of your fiduciary duty as a majority shareholder if you use that position to merge out the minority for cash with no proper purpose. Maybe proper is not the right adjective, but with a business purpose or something. And there was none there in the facts of this case, so they reversed and sent it back for trial. And I think it eventually settled. I never had to end up trying the case, but when Weinberger came along, the complaint that came in was basically what Singer authorized. The plaintiff simply said that Signal Company, or whatever Signal's, the rest of Signal is, I don't remember now, but that was the majority shareholder. And they had owned 50.5% of the stock of UOP and had merged out the minority for cash. And the complaint said this happened and there was no business purpose. So it didn't take many pages to get that.
And it didn't take long for the defendants to land a 1-2 punch that looked like a knockout blow. In the space of just 3 days in April of 1979, Chancellor Brown's rulings on motions to dismiss purported derivative claims and to certify a class turned what had been a derivative suit and a class action on behalf of almost 5.7 million shares into a class action on behalf of only about 150,000 shares. Chancellor Brown explained why.
You end up certifying Mr. Weinberger as a class representative, but then you cut down the class size to stockholders who hadn't voted in favor of the deal.
Yes.
What was your rationale?
The way, again, that Signal had structured the merger by giving the minority the chance to vote it down if they wanted. And trying to think if there's anything else. I'm sorry, ask me again.
Well,
what was the class, cutting the class?
Right.
Yeah. It was like 147,000 shares or whatever that hadn't voted. The merger was overwhelmingly approved, like 12-1 by the minority. And with Signal's holdings already, it went way past the 2/3 requirement that they put as a condition for going through with a merger. So, I don't know, it just seemed to me that under the circumstances, those people that were happy with the merger price, which was, I think, $7, something like $7 or $8 a share above the market price when the merger was announced, I didn't really see why they should be coming back in to maybe get more, but I thought those who voted against the merger certainly were entitled to be represented. So I thought, in my mind, the logical approach would be to make the class the people who opposed the merger, who didn't want the $21 a share, wanted something else. And the rest of them were happy with $21 a share,
Plaintiff tried to appeal the order drastically limiting the class, but that attempt failed. At that point, the case might have seemed impossible to pursue on a financially rational basis.
the court also made a ruling on the size of the class and cut it down from the proposed class of 5.7 million shares to 147,000.
Correct.
Which must have been a big blow to the plaintiffs at the time, because they immediately sought an interlocutory appeal, and they argued in their appeal papers that the practical effect of that ruling was to deny class certification altogether. and then the appeal gets refused. At that point, did you think you had won the case?
I don't have any recollection of what I thought when that happened. I mean, obviously, he was going to have to do something. Either the case was over, as a practical matter, or Bill was going to have to do something to change that result, because it wasn't economically feasible to try a case with 147,000 shares.
And matters soon got even worse for the plaintiff. Defendant's next move was to dismiss the complaint in what was left of the class action, a move foreshadowed by one of Chancellor Brown's more memorable musings in his class certification opinion, describing the class action complaint.
You also described the complaint as, quote, a document perhaps artfully drafted as such, possessing certain chameleon-like characteristics which enable it to change its appearance while under scrutiny of attack. It's a colorful metaphor. What were you describing there?
I'm not sure I remember exactly now in a degree, but it just, I think it's because there was nothing in it, as I remember. It was basically just, there was no business purpose for this. There weren't any allegations of fraud or misrepresentation or anything dastardly done by Signal. Just that Signal had no business purpose. And under SIGR, that's a violation of fiduciary duty. And, give us our damages, Your Honor.
You did end up dismissing the complaint, but then allowing leave to replead. Could you say a little bit about the decision to dismiss it?
Well, the reason was the way the merger was structured. Signal was apparently, through counsel, crafty enough to see that they had a potential problem under Singer if they just came in and used their majority share, 50.5%, not even 51%, to cash out the other 49.5%. And so the merger was structured under the merger agreement that before this could happen, it required a majority, I think I got this right, tell me if I'm wrong, but a majority of the minority shareholders voting on the merger. That had to occur, number one. And number two, if there was a majority of the minority shareholders voting, that number of shares that voted, coupled with Signal's share, had to represent 2/3 of all the outstanding stock of UOP. And so I thought, well, that's not what happened. That's not the problem Singer was addressing. Singer was addressing where you just use the numbers. I got 51%, we're cashing you out. Got to have a business purpose for that. But on this one, Signal didn't do that. They left it up to the minority shareholders to a degree. In other words, it didn't use its controlling position to put it through. There was always a chance that shareholders could have turned it down. I'm sure they weren't worried about it, given the price they were offering. But at least it was tactfully structured that way. And so I thought this complaint that says nothing other than there's no business purpose doesn't pass muster, so threw it out.
Threw it out, but not for long. With a leniency in pleading that no longer exists in the Court of Chancery, plaintiff got another chance.
It seemed to me, under the circumstances, I ought to be realistic. And since we were all dealing in kind of a new ground, lawyers as well as the court, given the opportunity to file an amended complaint, it was a big company. There was, what 11 million shareholders or something. I mean, it was a large company and a lot of people involved, and it seemed to me a lot of time had been put in it. And it just seemed to me that they ought to have the opportunity to file an amended complaint.
So at this point, he has gotten discovery. His complaint gets dismissed,
Right.
but he's able to amend it with the benefit of his
Correct,
discovery.
exactly.
Could that happen today?
Probably not, because we have Rule 15, I think it's, 15 triple I or some
AAA, right?
yeah. And that says that he would have had to have done it after the opening brief on the motion to dismiss, and if you didn't do it, then you couldn't wait around till you got an opinion. You would have to amend at that point. Now there is a little bit of weasel language in that rule that says, for sort of like for super good cause shown, you might still be able to amend. But I think most practitioners, if they're going to amend, look at the arguments that the defense has made, and amend then, so as not to run afoul of that rule. But that rule was well in the future, beyond this point.
So the case survived and proceeded with discovery and to trial in May of 1980. Pretty fast for a case that had been dismissed just 6 months earlier. And like most everything that plaintiff's lawyer Mr. Prickett did, it was an unconventional trial, especially as it involved evidence about the value of UOP and the fairness of the $21 per share merger price.
I want to ask about the experts,
Yeah.
and specifically the defendant's expert who presented a valuation based on the Delaware block method.
Right.
What is the Delaware block method?
So back when I started practice, and as it will come clear as we move forward here, for the first 10 or 12 years of my practice, when you did an appraisal case, you had three factors that you considered. You considered the earnings value, which generally meant that you looked at 5 years of historical earnings and averaged them out, and applied some multiplier to those. You look at asset value, which was what it sounds like, the fair value of the company's assets, and you looked at earnings. You looked at market value, and then you weighted them, based on the nature of what the business was. So the example I used to use was if you had a bunch of land held for development, which was presently a cornfield, that you'd give a higher weight to asset value in that circumstance than you would to a factory that was producing something, because you're already getting value out of the earnings side of the equation from the producing factory. And so, depending on what you were talking about, you would weight these. And market value, the market value before the deal was announced, not taking any consideration of synergies from the deal, was the third factor. And if it was a public company with a widely traded market, you would put a higher percentage on that market value than you would if it were a private company. In fact, in some private companies, there was no market value, or no discernible, or very lightly discernible market value with a few scattered trades. So that would get a low percentage in that case. So depending on the nature of the company, you then total that up, and that would be your value. You'd apply the weighting to each of them, and then you come up with a number, and then that would be the value. Differed from the way people think now, largely because it assumed that the past is a predictor of the future. So you were looking backward, at least in terms of the earnings value and the multiple that you put on it.
The plaintiff's expert conducted a premiums paid analysis and
Right.
then rolled out a discounted cash flow analysis.
Right.
At the time, did you believe that the discounted cash flow analysis was going to get traction before Vice Chancellor Brown?
Not really. I mean, not only did the Vice Chancellor sort of dump on Bodenstein's discounted cash flow analysis, but other judges in other cases had commented on the speculative nature of discounted cash flow analyses, which varied tremendously based on the discount rate you applied, the terminal value you selected, et cetera. So while the technique was becoming more widely used in the investment community, it really hadn't gotten any traction yet in the Delaware courts.
You mentioned the experts. The defendants proffered an expert who presented a valuation based on the Delaware block method. Mr. Weinberger and Prickett Jones presented Ken Bodenstein, who
proffered a valuation based on a premiums paid analysis and discounted cash flow. Why?
Well, Ken was out at Duff and Phelps, and Ken told Bill Prickett, well, these are the methods that actually get used in valuing companies. And it wasn't the Delaware block method, but Bill was convinced that this made sense, and so he went forward with Ken's analysis.
At the time, the Delaware block method was the valuation method. It seems incredibly risky to present an expert who discards it in favor of a discounted cash flow analysis. Why was Bill Prickett willing to take that kind of risk?
He was convinced that Ken knew what he was talking about, and that it made sense that the value of the company was based on what you anticipated it was going to produce in terms of cash flows in the future, rather than a more historical analysis of what the company had done in the past. Because there have been companies that have done well in the past, but they're not going to do well in the future. There are companies who may have struggled in the past, but are expected to do very well in the future. So that really was a turning point in terms of the focus on valuation of companies.
At the time, did you expect discounted cash flow analysis to catch on?
I don't know that there was a real expectation that, and obviously it didn't catch on with Chancellor Brown. He essentially rejected it twice, once after trial and once on remand at the damages trial. And he considered it, but he ultimately concluded that there were elements that were too speculative, particularly the discount rate. And so he didn't use it.
The plaintiffs proffered Kenneth Bodenstein, who presented a premiums paid analysis and a discounted cash flow analysis.
Right.
What was your reaction to that?
Well, the premium based on comparative transactions, that wasn't, to me, unusual. It had that. I think that normally came in. An expert would look at other merger acquisitions, that sort of thing, similar over a period of time, and see what was paid and that sort of thing. Use the numbers, see what kind of a premium over market price was paid in those things, and use that as a basis for coming up with their expert opinion for what the stock should be worth in this case. So that wasn't necessarily new, but this thing called the discounted cash flow analysis was completely new to me. But not Prickett. Prickett was out there sallying forth. He had Mr. Bodenstein. He was a nice guy, very, very cooperative, very qualified, I'm sure, but he had this way of using the elements for a discounted cash flow to come back to a value. And I kind of thought when I was hearing all this, what in the hell is he doing? You know, I can't use this. Delaware precedent says it's a Delaware block method, and you do it this, and he's coming in with Mr. Bodenstein, who's projecting out and discounting back and all that sort of thing. But you listen to it, and when it came time for a decision, if you're there yet, it seemed to me that it not only didn't jive with precedent, but it was a little too loose for putting a value of stock at the time, or putting a value on stock as of the time of the merger. And I don't know, just the idea was that you use projections and that sort of thing, and you get a figure way out here 10 years ahead, and then you discount it back by some percentage, and that percentage comes right out of the expert's head. I mean, everything up to that point is documented by numbers and all sorts of things, everything fine, but at the end, it's a question of whether you put 4%, 8%, 6%, or whatever, which comes out of the expert's head based on his experience. And I thought, that's not the way, as I understand Delaware law, that you value stock for the purpose of the takeout of the merger.
So I take it you didn't expect the discounted cash flow methodology to catch fire in Delaware jurisprudence?
I would have never thought about it, to tell you the truth, but I think not, because based on precedents and other cases that I had, I thought this is so far out beyond what Delaware law says. I can't imagine anybody's going to buy that.
And the Chancellor didn't buy it. And he didn't buy any of the plaintiff's basic contentions. On February 9th, 1981, after an 11-day trial and extensive post-trial briefing and argument, Chancellor Brown issued a 79-page opinion, huge for its time, concluding that there is no indication that Signal's purpose in proposing the merger was legally improper. There is no convincing proof that there was any misrepresentation or omission of material facts in the dissemination of information by UOP or Signal. There is no evidence which indicates by a preponderance that UOP's board abdicated its fiduciary responsibility. And there is an evidentiary basis for concluding that the merger price agreed upon was fair to the minority under the circumstances. In short, this was a devastating defeat for the plaintiff and his lawyers. It could have spelled the end of the case, but defense counsel knew their adversary better than that.
Did you expect that the case was over, or did you think that there would be an appeal?
Oh, I thought there'd be an appeal. He had already appealed, had an interlocutory appeal on one matter. By the time I got to Van Gorkum, I knew when there would be appeals, because I knew Bill would never quit. He would play it out to the end, and I think I sort of knew that by this time.
And of course, there was an appeal. After briefing over the summer of 1981 and oral argument in September, the Delaware Supreme Court issued its opinion in February of 1982. But not the opinion you're likely to have read. This was a 5-page majority opinion by Justices Quillen and McNeely, with a 5-page dissent by Justice Duffy. The other justices, Chief Justice Herman and Justice Horsey, were apparently disqualified and didn't participate. Keep that fact in mind.
Justice Duffy, Justice McNeely, Justice Quillen are the decision makers, and they affirm.
Yes. I had forgotten that. It was refreshing to find out that I did get affirmed somewhere along the line.
With a dissent from Justice Duffy. Were dissents rare?
I think so. I think you could say that back then. Occasionally there'd be one.
At this point, at the time of the affirmance, did you recognize that this was going to be a big case, or was it still just any other case?
At that point, just any other case. I had given a thorough, documented, windy, reasoned decision, and it was affirmed 2-1. And Justice Duffy, in his dissent, he didn't like the way I did a couple of things, but his main dissent was, I think, had to do with Lehman Brothers, wasn't it? That I kind of threw. Lehman Brothers was a financial advisor that had put the blessing on the price of the merger and all. And he thought they should have had some fiduciary duty, and I wasn't aware that the financial experts had any fiduciary duty. So he would have reversed on that. But he also said he thought, I think that somehow I put the burden on the plaintiff to show the price was unfair, when really, under established law, and particularly under Singer, I suppose, the burden would have been on Signal to prove the fairness of the price.
So
I mean, I can add my personal view is I can, knowing Justice Quillen and Justice McNeely, whom I knew both very well for a long time, I'm sure they took one look at 79 pages and all this stuff and said, we're not going to mess with that. He's got enough there. It's a reasoned decision. We'll affirm. I'm sure that's how it came about.
So at this point, you've gotten a full defense judgment at the trial court level. The Delaware Supreme Court has just affirmed. Did you think the case was dead?
Well, I figured there'd be a re-argument of it because of the dissent. Now, at some point in time, the court, as a matter of policy, came up with a policy that if there were a dissent, then there would be a rehearing en banc. I can't remember whether that policy was in place in 1983 when this opinion came down, but you at least figured there'd probably be a motion for re-argument because of the dissent.
The appeal goes forward, and then the post-trial opinion gets affirmed by a majority, and there's one dissent. But it is an affirmance. At that point, did you believe that the case was over?
Not if you were Bill Prickett, you didn't. Justice Duffy had dissented on both as to the Lehman Brothers issue and as to burden of proof. He believed that the chancellor had put the burden on the plaintiffs and it should have been on the defendants. There was a practical problem that even though it was an opinion by 3 out of the 5 justices, Justice Horsey and Chief Justice Herman had filed notices of disqualification, which meant they weren't available. So the opinion of the 3 justices was considered a decision en banc. And so the only recourse was a motion for re-argument that initially would be in front of the same 3 justices that had just rendered the opinion.
It seems incredible because the Court of Chancery has cut down the class from 5 million to 140-some thousand shares. It has dismissed the case once with leave to replead. The case gets tried and results in a decision for the defendants. It then gets affirmed on appeal by the only judges that are available to hear the appeal.
So, the end of the line, right?
And yet there's a petition for rehearing. And then something incredible happens. It's I think the biggest comeback victory in Delaware jurisprudence. What was Mr. Prickett thinking that got him confident that a petition for rehearing in front of the same judges would work?
I don't know that Bill was confident. Bill used to say, what's the fastest thing in the judicial system? The denial of a motion for re-argument. So I don't know that he had, but he had come that far, and he was going to, and he had one justice that had gone his way. So it's could you change the mind of one justice? So he proceeds, and you then have an unusual sequence of events that occurs.
I want to ask about that, and particularly I want to ask about the dismissal of Lehman Brothers, because it seems as if the plaintiff decides to dismiss Lehman Brothers to reconstitute the court. Is that what happened?
Well, it was certainly to remove the conflict for the Chief Justice, whose son was a partner in one of the firms representing the defendants. The plaintiff had said that was okay, but the defendants did not waive that disqualification. And so then a sequence of events happens. Justice Duffy, the one justice that had gone plaintiff's way, retired on March 31, 1982. So now he's gone. But Justice Moore gets appointed in May of 1982. Then Bill filed this motion to dismiss Lehman Brothers, and it was very explicit that he was doing this to eliminate the conflict on behalf of the Chief Justice. And ultimately, the Chief Justice on June 15, 1982, withdrew his disqualification. That was only 8 days before the matter was re-argued. Meanwhile, Justice Horsey's basis for disqualification had also cleared. So now you had a hearing in front of 5 justices, Justice Quillen and Justice McNeely, who were on the initial panel, and then 3 justices, including the Chief Justice and Justice Horsey and Justice Moore, who had not previously heard the case. So the hope there was, well, maybe we can convince the 3 new justices to reverse.
I'll just talk about this because it's an important part of what happened. Whether it would have changed the result or not, who knows? But one of the justices that wasn't on the panel was the Chief Justice, Daniel Herman. And he wasn't on the panel because his son is a partner at Richards, Layton and Finger. And Frank Bellotti of Richards, Layton and Finger was representing Lehman Brothers. So he couldn't sit. The other person who wasn't on the panel was Justice Horsey. And there's a comment in some of the later papers about some time limit that had to expire, and it hadn't expired before Justice Horsey could sit on this case. And it hadn't expired at the time of the first argument, but it had expired at the time of the second argument. Now, I just don't remember what that particular time limit was, or what the policy of the court was that said you couldn't sit until some period of time went by. But I do know, I'm convinced to this day that Bill Prickett was smart enough to say, and what he did was he dismissed Lehman Brothers. Okay? That requalified Chief Justice Herman. He wanted a different panel than had decided this. And then Justice Duffy must have retired, and Drew Moore came in, and then Horsey's time went up, and he came on. So when the matter was reheard en banc, of the 3 judges that were originally there, only, well, McNeely was still there. I guess Quillen was still there.
2 left.
2 left, and 3 completely new ones. And it had to be that the dismissal of Lehman Brothers was to requalify Chief Justice Herman.
It seems brilliant because the dissent focuses on Lehman Brothers,
Yeah.
and one would expect that if you were to seek re-argument, you'd want to capitalize on Lehman Brothers, and yet
he just threw really well. It was so much more important to get a new panel than it was to try to exploit the dissent. Is the way I read it at the time.
So-
and do to this day.
the plaintiffs decided to throw away their claims against Lehman Brothers to reconstitute the court. It seems brilliant or dastardly,
Or something.
depending on your perspective.
That's correct.
And just 8 days after this extraordinary reconstitution of the Supreme Court, the court convened oral argument on the plaintiff's motion for rehearing, and it was dominated by the new justice on the bench, Andrew G.T. Moore II.
So let's talk about the court on rehearing. 2 of the justices are the same. There are 3 new personalities.
Right.
Is this court a totally different animal?
Pretty different.
How so?
Well, largely because of the personality of Justice Moore, and it was Justice Moore who jumped all over the Aldrich Chaitya report from the very beginning of the oral argument. he didn't even wait for Halkett to get up. He started making up his points with Bill Prickett. And at this point in time in history in our court, the court, even at this early point, it became even clearer as time went on, and we went to cases like Van Gorkum and some of the takeover cases, the Unicals, the Revlons. The court had sort of ceded the lead position in these corporate transaction type cases that it reviewed to Justice Moore. He was by far the most influential justice on the court, and particularly the relationship between he and the Chief Justice meant that every time Justice Moore said something, the Chief Justice sort of echoed it, and you can sort of see that in the transcript if you go back and look at it. So people came in to argue about one thing, and oh, by the way, the court decided in re-arguing, and what it did was it vacated the earlier decision. I mean, got rid of it. Had to get rid of it because it said it was en banc, and there's no procedure for having a re-argument of an en banc. So they basically said this was never really an en banc thing in the first place. So we get rid of that. We have re-argument, and we're going to decide it based on the briefs that were submitted through two or 3 years ago on the first argument. There were no new briefs. So. Which is a sort of strange thing. I can't remember seeing that much. In fact, sometimes the court is very helpful in these circumstances and actually tells the parties what's bothering it and says, please address question A, question B, question C. In some of the very biggest cases, they did that. They did that in Unical, for example. But here they didn't, and it all happened at oral argument. And after sitting there and listening to umpteen questions about how could you possibly not think that this Arledge Chatea report, prepared by two UOP directors who are also signal directors who using signal information, how could you possibly believe that wasn't a breach of fiduciary duty? And you hear that about 5 times. You say, when is it that you realize you're in trouble in a case? Well, on that one, I had to have realized that we were in trouble. It was pretty clear where they were headed. Now, it's not all of the things that they decided in the opinion, and there are a ton of them, where they really remade the law in terms of controlled mergers. All of those things weren't raised in oral argument. Many of them weren't even discussed by either side in the briefs. But on this point, which was the real point, and if you look at it closely, I think the result would have been different if there hadn't been an Arledge Chatea report. On this point, it was pretty clear where they were headed. So I'm sure that the drive back from Dover to Wilmington was not a gleeful one.
Wait a minute. Did he say Arledge Chatea report? What's that? And why haven't we heard about it before?
It was a signal document that reflected on at what prices an acquisition of the minority of UOP would be beneficial to Signal. It had a lot of good stuff in there to use if you wanted to say it's a document that should have been disclosed to the shareholders, minority shareholders. Well, I never thought it was anything more than what it was offered to be. It was somewhere along the line. Arledge and Chatea were members of Signal's management. They were vice president each of something, I don't know which. They were also on Signal's board, and they were also on UOP's board. And the inference was somehow from now all of that Signal's board had to be aware of this and would have considered that at any price between $18 and whatever it was, $24 a share, would have been beneficial to Signal, a good investment for its money. And I just wanted any proof anybody considered that, but the Supreme Court said, well, it was there. And somehow the minority shareholders, I guess, should have been made aware of the fact, even if nobody at Signal's board considered it or UOP's board considered it, the minority shareholders should have been made aware of the fact that there had been an analysis made by Signal management personnel just for informational purposes, I think, that said you could pay up to $24.
The Arledge and Chaitia report plays a huge role in the appeal. It appears just once in the post-trial opinion in the background section. Did it play a big role in the trial?
No. Absolutely not. I mean, it just wasn't brought, it was in evidence. I think it was, obviously it was in evidence, it was a document, but there wasn't any big discussion about it. It certainly didn't take on an importance, took on no importance, quite frankly, at the trial. Nobody made any kind of an argument that was anywhere near what the Supreme Court found when it reversed. As a matter of fact, I think one of my later decisions reviewed for the purpose of this interview indicated that neither Arledge nor Chaitia testified in the trial. They weren't called as witnesses. They were on the witness list. Could have been called. They weren't there. And I think somebody pointed out that Mr. Bodenstein, the expert witness for Bill Prickett trying to establish value and all, he was on the stand for the better part of 3 days, and he only mentioned it once, the Arledge and Chaitia report. And it just never was anything there presented about Arledge and Chaitia. They didn't appear. The report wasn't, it was mentioned or something, maybe in a post-trial brief, I don't know, but it was not the big thing.
Did you expect the appeal to turn on that issue or other issues?
Well, I certainly didn't expect it to turn on that one. It never entered my mind. I mean, I understand the reasoning of the Supreme Court, but it seemed to me it was a stretch for the Supreme Court to attach that much significance to the Arledge and Chaitia report to get to a result.
A stretch, maybe, but one that generated the unusual step of an attempt to clarify the factual record after the oral argument.
And there was a letter that we sent after, which is very unusual. There was a letter we sent after the argument based on some testimony by Walkup, who was the chairman of the board of Signal but had been at the UOP meeting, where he had a recollection that he had shared the Arledge-Chaitia report with the UOP board. But there was no corroboration of that. There was some sense that maybe a couple of pages had been shared. And in the end, the Supreme Court actually said, we did fact-finding. We went back into the record and we looked at the record, and we believe on the balance of facts, which is sort of a trial court function, that didn't happen, and therefore they then build its decision around that finding of fact.
And that finding of fact relates to an issue that wasn't even the focus, either at the appellate argument before or at the trial level.
Or in the briefs before the Supreme Court, which had been written 2 years before for the first trial. For the first appeal.
Signal's letter to the court left plaintiff's counsel in an unusual bind.
The oral argument before the reconstituted court includes a colloquy about the Arledge and Chaitia report. And it turns out to feature critically in the outcome. What happened?
Well, as often happens on appeal, things that may have been in the record and discussed, but in a trial situation, there are a lot of issues and a lot of different things. There came to be more of a focus on the Arledge-Chaitia report, and it was discussed a good bit at the argument. Then subsequent to that, Bob Payson sent a letter to the Supreme Court on behalf of Signal, basically arguing as to when the Orlich-Chaitia report had been known to various directors. That then prompted a responsive letter, but Bill Prickett happened to be out of the country at the time, so it really was John Small who headed up that effort. And we went back and from the documents and transcripts, put together the chronology and submitted that. And it was only at that point that the matter was considered to have been submitted to the court.
Do you recall whether you and John Smalls submitted that with input from Mr. Prickett, or was he completely unavailable and therefore you're left to submit this critical letter back to the Supreme Court?
Yeah, well, back in those days, no email, no cell phones. And Bill, I don't recall specifically where he was, but Bill would go on, like treks in the Himalayas, and he went on another trek out in outer Mongolia. So my recollection is Bill was someplace where basically you couldn't communicate with him. So we got this letter, and there needed to be a response, and so we just had to do the best we could in terms of reviewing the record and being able to respond to what the defendants had put in.
And then silence for over 6 months until February 1st, 1983, when the Delaware Supreme Court issued its now famous opinion in the case.
Fast forward now to the opinion from the reconstituted Supreme Court. It is totally different than the Supreme Court opinion affirming the trial court just a little while before. And the tone of the opinion is totally different. To what do you attribute that?
Well, you had 3 new justices, including Justice Moore, who wrote the opinion, and he obviously took a different view of things. I think the interesting question is that Justice McNeely and Justice Quillen, who had come out the other way, joined in the opinion, and it was 5-0. That was a surprise. There may be things in the opinion that may have been intended to win over, say, Justice Quillen, who I think was very much believed that appraisal should be at least the primary remedy.
One more question before we leave the appellate decision. Justice Quillen and Justice McNeely had been on the opinion affirming you.
Yes.
They also sign on to the opinion reversing and remanding. Did you ever learn how it was possible that they could be on both sides of this issue, quite like they were?
No, I never learned. I just, presumed they became enlightened. I think, I thought somebody, that's why I got to blame Drew on it, I guess, because I thought somebody caused them to see a different perspective on things. And I don't really, as I said, I doubt they put a lot of time in on that first decision just because of the way it was. It was on facts, it was a lot of facts, it was 70 pages long, and, I had an analysis in there of whether the Singer case affected something, all that sort of stuff that they didn't really need to put a lot of time into. I'm sure they had other things to do too, We were all busy in those days. But my guess is, without knowing, I thought when Justice Moore got in there, he's a fresh voice on the court. And he probably, knowing Drew, he sat him down and said, look, we got to do something about this. And this is a case to do it in, and here's the points we have to make, 1, 2, 3, and they agreed.
And the case went on from there for over 2.5 years, but with only a few anticlimactic matters worth mentioning. One of the first things Chancellor Brown had to handle on remand was how to deal with the Supreme Court's suggestion that rescissory damages might be appropriate.
The parties, or at least the defendants, asked for a preliminary hearing on
Rescissory damage.
and essentially what to present to you at the trial on damages.
Yeah, the defendants, that's right, the defendants, they were concerned. I seem to remember vaguely after the decision, all the counsel coming into chambers one time shortly after it, and somebody, I think it was Alan Halkett, the attorney from Latham and Watkins out in Los Angeles, said, "Your Honor, what do we do now?" And I said, "I don't know. We'll have to work on it," something like that. They didn't know how to proceed as a result of the Supreme Court's decision.
It raised, at a minimum, a big discovery issue, which was what to do about the changes in the business since the closing of the merger and how to put the parties in a position to present evidence on what rescissory damages should look like. How did you approach that?
Well, I was asked to rule rescissory damages out of the case on remand. That was the application, for the reasons you just gave. This is going to be a mess if you're in the rescissory damages. The merger's been over for years. We got to go back and get more discovery from years going back. We got all sorts of expense. Things are piling up. And if it's not a really rescissory damages case, you got to get it out now. And I think I don't really know how I can do that. The Supreme Court has kind of sent it back, and I guess they said rescissory damages if found appropriate or something, but I think at the time, I'm not even sure I recognize what rescissory damages were supposed to be or how you got to them. I'm not sure I could explain it now, but it's like if the merger was wrongful and shouldn't be upheld and should be undone, if you rescinded it, you would put people back to where they were before the merger, stockholders. Well, you couldn't do that because time had passed, years, and so you would have had to work out somehow a value somewhere in between in those years, pick a date, and from whatever the reasons you can accumulate, but say as of this date, if this merger had not occurred, I guess I should be better. Merger had not occurred, and these people still had their stock. What would it be worth then? And then you would take that number and deduct the $21 a share from it, and that's how you would get the rescissory damages. In any event, they asked me to rule rescissory damages out, and I said I can't do it at this point. I think probably because I didn't know enough about what everybody was talking about. And since the Supreme Court had suggested, if warranted, rescissory damages, I didn't, having been reversed once, big time, I didn't think it was appropriate to get rescissory damages out ahead of it. I could see where they were coming from. They didn't want to have to go to the trouble, they didn't want to have to go to the expense and that sort of thing, but trouble and expense hadn't been any problem for 4 or 5 years or whatever this has been going on, so we just do it a little more. And I did say I'm not going to award rescissory damages, but I'll wait till we get. Go get what you want, bring it in, and we'll decide whether rescissory damages are warranted or not. So I declined the motion.
Still, the trial on remand ended up looking not very different from the first trial.
It was largely a somewhat expanded version of the damages case in the original trial. You had Ken Bodenstein there with a discounted cash flow analysis and other analyses, and you had the defendants obviously they didn't rely on the Delaware block approach because the Supreme Court had kind of indicated, well, you're going to have to consider these other methods. And what they set about doing was trying to show that the discounted cash flow method was speculative, and with respect to rescissory damages, that was also speculative. There had been intervening events and so on. And so, their approach was largely to say, there are no damages here. And you got a significant as often has proved to be the case in valuation issues in cases, the judges still lament, as Chancellor Brown did then, that there was this big gap between the plaintiff's expert and the defendant's expert as to what the value was. The defendants actually tried to show that if you had gotten a greater sum earlier on, at the time of the merger, and you considered what you might have earned on that, that actually there were no damages.
And so, what started out as a case barely clinging to life after several near-extinction events, and climaxed in a dramatic reversal by the Delaware Supreme Court, ends up with an award. $1 per share that barely tipped the scale and left the plaintiff's counsel, Bill Prickett, thoroughly unsatisfied.
The court decides that it can't award rescissory damages, and it goes on to say that the minority, and I'm quoting here, should be compensated for the wrong done to them, even though a damage figure cannot be ascertained from a comparison of selected stock values and hypotheticals with any degree of precision. It suggests that the court is very uncomfortable with any damages analysis.
Chancellor Brown hated this case. I mean, it was clear from the beginning he didn't like this case. There was a 50% premium being paid to the market. Almost nobody, 147,000 shares out of 5 million didn't like it, or at least demonstrated they didn't like it by not turning in their shares or voting against it. And I just think he thought, and the nature of Bill Prickett's complaint was like, first it's filed a couple of months after the merger, rather than anybody trying to enjoin the merger when it could have been straightened out in a timely way. And then it clearly takes on the look of a complaint searching for a cause of action. You file one, that doesn't work, so you then come up with another one. Yes, you had the benefit of discovery, but the stuff that he came up with wasn't very persuasive. Nobody raises in the court below Arlen Chartier, and all of a sudden the case comes back to him. And I just think he said, I've had enough of this case. But I mean, the whole idea that there was going to be any way that you could pick a time and say, I've got a time where rescissory damages were here, and it would have been appropriate, and somebody would have done better than 21. There was no way he could have decided that. Just no way. There's no way with any intellectual integrity. So then he's left with Purcell's testimony, where I guess in this trial we must have had Purcell do a discounted cash flow. I think we did. And he's got Bodenstein, and he didn't like Bodenstein's testimony any more than he liked it the first time. And so what's he left with? And he doesn't call it nominal damages, but that's probably sort of what it was. He says, well, Purcell said he could have given a fairness opinions at 20 or up to 22. I mean, well, yeah, that's not really very exciting. He could have given a fairness opinion at 100 to the minority stockholders of UOP. And he has a few other words about, and I know I have to give him something because the Supreme Court has said that they've been deprived of the right to intelligently make a decision. But on the other hand, he says, but don't forget that we are only in this box because Signal created it by trying to be generous to the minority by making it a majority of the minority vote in the first place. So I'm giving him $1 a share. So think about that. So the class has been expanded, obviously, because it's now a disclosure case from 147,000 back to 5 million. So we've got a $5 million judgment. And by the way, by this time, Signal had merged with Wheelabrator, and then I believe it also merged with Allied, and it had become Allied Signal. None of the people at Signal were even there anymore. And Signal was like, 5 times larger than it ever had been before. $5 million to Signal was nothing. I mean, it was chump change by this point. And so poor Bill, having put in thousands of hours over the course of 7 years, ends up with a $5 million judgment, of which I don't remember what the fee is, but assume he got the largest fee that our court would theoretically give, which would be for all the effort he put in, which he would have clearly deserved a fee of a third. I don't know if that's what he got, but we're talking about, less than $2 million for thousands and thousands of hours, and in his and to add insult to injury, so we get the opinion from Grover Brown, who was by then chancellor, about $1 a share.
So the damages trial goes forward,
Yes.
and the opinion on the damages trial gets issued in January 1985. It seems as if you're as uncomfortable with rescissory damages as you were with the discounted cash flow analysis. But then you award damages anyway. How
Well,
did that come about?
I just assumed as a practical matter from the Supreme Court decision, they held that the minority shareholders had been wronged and sent it back on a remand. And I said, well, if I just haul off and say no damages, going back up on appeal again, and they ain't gonna put up with that, I don't think. So, and the case has been going on long enough. I thought that on this remand, as I interpreted, some award of damages is expected. I got to come up with something by way of damages to get this thing over with. But to come up with something for damages, I got to find something I can justify. I can't just pick a number out of the air. I mean, you sat around there and thought, maybe I'd give them $3 or $4 a share or something like that. But hell, there ain't any way I could justify it on the evidence. I didn't have any basis for saying $5, $10, or anything else. But I thought I had to come up with some kind of damage. So I'm probably anticipating a question of yours, but I thought maybe root around in the evidence and see what's in there that I can work with. And I know, I'm sure Bill was greatly distraught to get $1 a share, but there was something in there. I think who was it, the Dillon Reed guy?
Mr. Purcell.
Mr. Purcell, and early on, before the merger and some of his things, he had pointed out that for Signal, that paying up to either $21 or $22 a share would be all right. So I thought, well, we got Signal's expert that way back before all this mess started said it would be all right, fair to the shareholders and fair to Signal to pay $22. They paid $21. That's $1. At least I got something to go on. And there's 5.5 million shares out there. And, that's not insignificant to me. It's $5.5 million. I mean, it's insignificant to Bill. He was probably going $50 million, but I wasn't really concerned about him at that time, as much as I liked him. But so anyway, I figure I got to come up with something to end this. And what have I got in front of me on remand? They came in with the rescissory damages nonsense, and I couldn't buy that. It was just too speculative as far as I was concerned. I think in the Supreme Court opinion it said something, there was something, the word speculative was in there. You can award damages as long as they weren't speculative or something. So. But this idea of having to try and figure out what a share of stock would be worth at some point, that you didn't know what point. How'd that go? I think the experts, what was it? You can help me out on this because but you had to use a date. And they used a date that was, the end of a year, whatever it was, but they picked a date because it was the closest or something to the date of the Supreme Court's decision, and it was closest to something else, I can't remember what. So how in the hell do you get anything logically justifiable? That's all I could work with. I mean, I'm not faulting them, but there wasn't anything you could get to. So they're basically saying, well, Your Honor, you're going to have to pick a date somewhere between this point and this point as to what the stock would have been worth if it hadn't been a merger. Now, to get to that point, we got to use the end of December of this year and the end of December of that year because they're closest to a Supreme Court decision. And, you know, how in the hell do you put all that together to get the value of stock on a certain date? It was beyond me. It would have taken somebody with more academic ability than me to get to that.
I think the chancellor went through these different theories, decided no rescissory damages. Then in terms of compensatory damages, kind of said, well, discounted cash flow is too speculative. And really then kind of said, okay, well, what am I going to do here? And he believed that there ought to be some award because the Supreme Court had found misconduct, though he really focused on the Supreme Court's opinion as if it was only about disclosure of the Arledge-Taitea report, and didn't really weigh as much the other, what we'd call now unfair process elements in terms of timing, initiation, structure, board approval. And so I think he felt like $1 per share was a decent award given the circumstances. But I think Bill Prickett thought he got shortchanged a little bit on that.
Right. Was he disappointed?
Yes. And you can see that in Vice Chancellor Berger's opinion subsequently on attorney's fees. Bill tried every way he could to increase the award. He asked that Signal should have to pay the attorney's fees rather than having them paid out of the fund. He wanted all litigation costs paid by the defendants. He got court costs and expert fees, but not the others. And there was a dispute over whether it should be compound interest, and he didn't prevail on that. And at the end of her opinion, Vice Chancellor Berger says, well, let me make it clear. I'm not faulting the plaintiff for trying to increase the recovery, but I think an element of that was that Bill felt at the end of the day that it really wasn't enough. Some of it was, even with an expanded class, it was a small class. It was 5.6 million shares. Oftentimes you see classes these days where there may be 100 million shares. $1 a share would be a whole lot of money, but because of the small class and what could be viewed as a somewhat nominal award, the ultimate financial outcome was not as good as Bill had hoped.
So, of course, he appealed, hoping for another miracle from the Delaware Supreme Court. But lightning never strikes twice in the same place.
I pretty well recall that I had a part in this. I think I was the instigator and said, why don't we do a motion to affirm? Because I said, I don't think the Supreme Court, first I had all this language about discretion. We're giving it to the discretion of the court below. And I said, I don't think the Supreme Court has any stomach to hear anything more about this case. So why don't we try a motion to affirm? So in Delaware practice, if the plaintiff appeals, which Bill Prickett did, he appealed $1. He said this was like nothing. This was a horrible result. And we originally cross-appealed, and then we decided not to cross-appeal. So we withdrew our cross-appeal. Instead, we filed a motion to affirm. And a motion to affirm basically says the defense is saying that you're not allowed to say any argument. You just say, we move to affirm, and the standard on the motion to affirm is just looking at the appellant's brief that there's no way they can win. That's basically how a motion to affirm works in the Delaware court. And the court summarily granted a motion to affirm. Bill moved to re-argue. They summarily got rid of the motion to re-argue, and that was the end of the case. So it finally ended, and it ended in a very truncated, unusual way. It was sort of like nobody wanted to have anything to do with this case anymore.
Still, as our participants explained, the UOP case survived enough to leave a huge footprint in the sands of Delaware corporate jurisprudence.
Looking back on Weinberger now, can you pinpoint the moment when you realized this is a big case and I'm working on one of the great Delaware corporate law decisions?
Well, I think after the Supreme Court's opinion, it was obvious that this was going to be a significant case. There may have been debate over what it was going to ultimately mean, but I think there was a recognition right off, not just by my firm, but I think a lot of other folks, that this was going to be, an important case. And then through the years, and we're now a lot of years after Weinberger, it has remained one of the central cases in Delaware law. And you still have complaints that are largely framed by Weinberger.
What it left behind was an entirely new regime in terms of parent-subsidiary mergers and cash-out mergers, which survives to this day. I mean, it is nobody after this opinion would really do a cash-out merger without having a special committee of outside directors negotiate. I don't think anybody would ever. I think by this time you would think 3 times before you had picked an investment banker that had where you had a director from that investment banker on the board. All of these things were basically dictated by this case, which really revolutionized and brought into the modern era how we deal with this type of conflict transaction.
There's a discussion in the Delaware Supreme Court's opinion about special committees. Was that something that seemed new at the time, or?
Well, I think it wasn't. I think they said a committee of disinterested directors, and it was in the context of there being a substitute for arm's length negotiation, because the fundamental problem was that Signal was on both sides of the transaction. They controlled UOP, they controlled the UOP board. Now, they did have a majority of the minority stockholder vote, but in the entire fairness context, the Supreme Court was saying, well, you have to look at it. Was this really an outcome that you would have had if you had an independent negotiating entity? And that continues to be an issue to this day. And we have, the idea that independent committee plus majority of minority, changes the standard. And that's, all these years later, those kinds of issues are still playing out.
I think people looked at it almost like the Supreme Court writing a law review article or a statute for all the things that were in the opinion. Doing away with the Singer-Tanzer-Najar business purpose test, saying that this could have been completely different if there had been a special litigation committee formed of the independent directors to negotiate, abandoning the decades-long block method of deciding appraisal cases and saying we're going to apply an expanded, more liberal method, including things like discounted cash flow, both to this type of case and to appraisal cases. They actually all go on and say we're sort of relegating. This was sort of hopeful thinking that never really happened, but we're sort of relegating people back to the traditional remedy of appraisal. I think they would hope to sort of end these cases and just have appraisal cases. That really didn't happen, but there were just all of these findings, many of which had never been discussed by the parties.
I do want to mention something that you said a moment ago about the Delaware block method. The opinion describes the Delaware block method as clearly outmoded, and then goes on to say that a more liberal approach must include proof of value by any techniques or methods which are generally considered acceptable in the financial community, and otherwise admissible in court, subject only to our interpretation of 8 Del C Section 262. Why did the Supreme Court do that?
Well, I think by the time we got, I think by the time we got to the mid '80s, it was pretty clear that the block method wasn't. No investment bankers were doing the block method in terms of actually making decisions on how to advise their clients in these types of transactions. It just wasn't. It wasn't modern, and frankly, Justice Moore knew that, and so he came in and said, "Well, this block method is and we're being laughed at. We're being laughed at in the business community because of the application of this block method. It meant that the values you were putting on companies for purposes of buying them didn't mesh with the appraisal values that somebody who dissented might get." And that could end up with a higher value or a lower value, but it wasn't. But it was pretty clearly not calculated anymore to give people what they had, a substitute for what they had before in any rational way. And of course, the worst thing about it is it was backward looking. So you look at. I mean, we all have been conditioned now for 40 years to look forward. And we look at projections, and we base our valuations in making decisions as to whether to buy stock or not buy stock, based on the projections that you see, and capitalizing those with some discount rate, and looking forward. I mean, 5 years is a long time. It's gotten to be shorter and shorter and shorter in terms of modern businesses. I mean, it might have been great to have Blockbuster's 5 years historical earnings, and you would have paid $1 zillion. But by the time you got to that point, it was already pretty clear that Blockbuster was on the way out and Netflix was on the way in. So it just didn't. That's just an example. I mean, there wasn't any litigation about that, but that's the difference, and that's become even more important as business cycles and innovation get accelerate and have accelerated.
There's a discussion about modernizing the appraisal statute, but the case isn't an appraisal case.
That's right, but they were saying we're going to view it as an appraisal case, a quasi-appraisal case, and they had some gibberish in there about preserving this quasi-appraisal remedy for cases that were in the court, or about to be in the court, or in the court below, and I don't know if that ever had any effect on anybody or anything. And then everybody else is going to get relegated to appraisal. Well, that didn't happen. And so, in effect, the valuation methodologies that it formulated continued to be used in various valuation efforts in takeover cases from this point forward. I like to think about basically Van Gorkum, which basically emphasized the duty of care and did some other things. Unical, which put a huge premium on having boards dominated by outside directors. In this case, which basically said, if you think you're going to come before our court again, things will probably be completely different if you have an outside negotiating committee made up of outside directors. So both of those cases put a premium. Those cases put a premium on outside directors. Modernized how you look at the economics, emphasized the fact that there better be a process, as Van Gorkum did, and put together those three cases, I think, have established a model which we, with a little tweaking here and there, rely on today to maximize the chance that these conflict transactions are as close to being arm's length as they can be. And I think those are the three opinions that probably were the most influential in shaping that total picture.
The final verdict comes from Chancellor Brown.
You know, it's a very interesting thing now to go back through all this. It wasn't terribly fun back in those days with everything else you had to do to, what, Weinberger's here again, you know? And, but looking back, it was a good exercise, I think, in the Delaware judiciary, trying to make sure that its corporate law was up to date with what was going on.